Every year, millions of parents are legally ordered to pay money to help raise a child they no longer live with. Some pay every month without fail, others pay nothing at all, and the children caught in between often have no say in any of it. Child support is one of the most personal intersections of law and everyday life. It involves income, custody, family breakdown, and the state, all at once. Most people think they understand how it works. Very few actually do. And the misunderstandings aren't just academic. They affect real financial decisions, real family relationships, and real children. It might seem strange that the government has a role in what are essentially private family arrangements. But child support law is built on a specific legal principle. Both parents have a financial obligation to their child, regardless of their relationship to each other. When two parents live together and raise a child jointly, that obligation is fulfilled informally, through shared income, shared expenses, shared household. When they separate, that informal arrangement breaks down. One parent typically becomes the primary caregiver, the other moves out. And suddenly, the financial support that used to flow naturally through a shared household has to be formalized and enforced by law. The state steps in for two reasons. First, to protect the child's interests. A child cannot negotiate for their own financial support. Second, to prevent the cost of raising children from falling entirely on the custodial parent and by extension on public welfare systems. In many countries, child support enforcement became much more aggressive in the 1970s and 1980s specifically because governments were spending heavily on welfare for single-parent households and wanted to recover those costs from absent parents. So child support law is not purely about family justice. It has always had a fiscal dimension too, and that matters for understanding how the system is designed. This is where most people's understanding gets fuzzy. Child support isn't arbitrary and it isn't purely up to a judge's discretion. In most legal systems, there are formal guidelines, formulas that produce a number based on specific inputs. The two most common approaches are the income shares model and the percentage of income model. The income shares model, used in many U.S. states and various other countries, tries to estimate what both parents would have spent on the child if they were still together, then divides that estimated cost proportionally based on each parent's income. The logic is that the child should benefit from the combined resources of both parents, not just one. The percentage of income model is simpler. It takes the paying parent's income and applies a fixed percentage, often varying by the number of children. No complex estimation of joint household spending, just a direct share of one parent's earnings. Both models have to answer the same hard questions. What counts as income? Salary is obvious, but what about bonuses, rental income, self-employment earnings, or benefits in kind? How do you handle a parent who is voluntarily underemployed, who could earn more but chooses not to? Most systems have provisions to impute income in these cases, meaning the court assigns a theoretical income level based on earning capacity rather than actual earnings. But applying that in practice is contested and often litigated. Custody arrangements also affect the calculation. If the non-custodial parent has the child for a significant portion of time, many systems reduce the support obligation on the theory that direct childcare costs are being shared more evenly. A child support order typically covers basic financial needs: food, clothing, housing, and general daily expenses. But child-rearing involves a lot more than that. Healthcare costs, childcare costs, school fees, extracurricular activities, and extraordinary expenses like medical procedures or special educational needs often sit outside the basic support order. Different systems handle these differently. Some require parents to split these costs proportionally. Others leave them to negotiation. Others don't address them at all unless someone goes back to court. This is one of the most friction-generating aspects of child support in practice. A parent receiving support may feel it doesn't cover enough. A parent paying support may feel they're being asked to fund expenses beyond their legal obligation. Without a clear framework for these additional costs, minor disagreements can spiral into serious conflict, and the child is usually caught in the middle. There's also the question of what child support is not. It is not payment for access to the child. Legally, in almost every system, custody and visitation rights are entirely separate from financial support obligations. A parent cannot withhold support because access is being denied. A parent cannot withhold access because support isn't being paid. In practice, these things get entangled emotionally even when they're legally separate, which is a persistent source of dysfunction in the system. Child support orders are not static. Life changes, and the law allows for modification when circumstances change significantly. If the paying parent loses their job, takes a major pay cut, or becomes seriously ill, they can typically apply to have the order reduced. If their income rises substantially, the receiving parent can apply to have it increased. If custody arrangements change, for example, the child begins spending more time with the previously non-custodial parent, that too can trigger a review. The problem is that modification requires going back to court or through an administrative process. It doesn't happen automatically. A parent whose income drops sharply may continue to be legally obligated to pay the old amount while waiting for a hearing. Arrears, unpaid support, accumulate, and in many systems, arrears are extremely difficult to discharge. Even bankruptcy in most jurisdictions does not wipe out child support debt. This creates a compounding problem for parents who fall behind during hard times. The debt grows, enforcement intensifies, and the path back to compliance becomes harder rather than easier. It's one of the most criticized features of child support systems worldwide. Duration is also often misunderstood. In most systems, support continues until the child reaches the age of majority, typically 18 in many countries, though this varies. Some systems extend support if the child continues in higher education. Once that age is reached, the obligation ends, unless there are specific provisions for disabled children who cannot become financially independent. Writing a support order is one thing, making sure it's actually paid is another. Enforcement is where child support law shows its teeth, and also where its limitations become most visible. In countries with strong enforcement infrastructure, the tools are considerable. Wage garnishment. Automatically deducting support payments from the paying parent's paycheck before they even receive it is one of the most effective mechanisms. Income tax refund interception, bank account levies, driver's license suspension, passport denial, and in some cases incarceration for willful non-payment are all used in various jurisdictions. The United States built an extensive federal-state enforcement framework starting in the 1970s and expanded dramatically in the 1990s. The system can track parents across state lines, intercept federal benefits, and report chronic non-payers to credit agencies. But enforcement has its limits. It works best against people with regular formal employment and traceable assets. Parents who work in cash economies, who are self-employed and can obscure their income, or who move across international borders are much harder to reach. And enforcement mechanisms designed for willful non-payment can be blunt instruments when applied to parents who are genuinely unable to pay, creating legal consequences that make it even harder for them to stabilize their finances and resume payments. There's a genuine policy tension here that most systems haven't fully resolved. Aggressive enforcement is necessary to protect children whose parents could pay but choose not to. But the same aggressive enforcement applied indiscriminately can trap genuinely struggling parents in cycles of debt and legal jeopardy that help no one, including the child. The formal legal structure of child support looks coherent on paper. The lived reality is often messier. Compliance rates vary enormously across income levels. Research consistently finds that lower-income non-custodial parents, particularly fathers, have significantly lower payment rates. Not always because of unwillingness, but because of genuine inability. The system was largely designed around the assumption that non-payment is a choice. When it's a consequence of poverty, unemployment, or instability, the standard enforcement toolkit doesn't work well and can make things worse. Informal arrangements are also common and under-acknowledged. Many separated parents never go through the formal system at all. They work out their own agreements, sometimes through mutual understanding, sometimes through family pressure, sometimes through religious or community structures. These arrangements may be more flexible and more respected, or they may be exploitative and unenforceable. The formal system exists in parallel with a vast informal world that law rarely sees. Gender dynamics are also worth naming honestly. The majority of custodial parents receiving support are women. The majority of paying parents are men. Child support systems have historically been designed with this in mind. But the landscape is shifting. More fathers have primary custody, more women are non-custodial parents, and some argue that the system has been slow to adapt its assumptions and its tone. Cross-border enforcement remains one of the most persistent failures. International treaties exist, but they cover only some country combinations, move slowly, and leave significant gaps. A parent who moves abroad to avoid support obligations is extremely difficult to reach. Child support law is attempting something genuinely difficult. It's trying to ensure that children don't bear the financial consequences of their parents' separation. It's trying to translate a moral obligation into a legal and administrative reality. And it's doing that across an enormous range of family circumstances, income levels, and life situations. The system has real tools. Wage garnishment works. Income guidelines create predictability. Federal enforcement infrastructure catches people who would otherwise disappear. These are genuine achievements, but the gaps are just as real. Enforcement designed for willfulness breaks down when the problem is poverty. Guidelines designed for stable employment struggle with gig work and informal income. Orders that look fair at the time of divorce stop reflecting reality when lives change, and no one goes back to court. What you shouldn't walk away thinking is that child support is simply about making deadbeat parents pay up. That framing captures one part of a much more complex picture. The system is also about administrative capacity, income measurement, custody arrangements, the limits of enforcement, and the fundamental difficulty of using legal mechanisms to manage what are, at their core, human relationships. Children's financial well-being after family breakdown depends on getting this right. And getting it right means understanding not just what the law says, but why it works the way it does, where it works well, and where it still falls short.